If I may, very briefly introduce the panelists, and excuse me if I'm going to miss out on any information that I may not be able to say, but just to introduce, from my left, I have Dr. Anni from the University of Glasgow, focusing on access to victims and evidence in national prosecution of core crimes. But I will start with Dr. Anni. Please, the stage is yours. Thank you.
Thank you very much. Can you hear me okay? Yes, good, okay. Good morning, everybody. Rosh Bash and Merhaba. It is an honor to be here today. And thank you to my dear friends from the KCIL for the impressive work that has been done to advocate for the implementation of international criminal law in the Kurdistan region. It is very special to see for me how over the last few years momentum has been created and now such a large group of esteemed practitioners, of lawyers, of academics from Kurdistan is gathering here. That is remarkable and worth mentioning in itself. And that then firmly brings me to reflecting on the topic for today, towards international criminal justice in Kurdistan. What I tried to do in my brief contribution is to reflect on this subject by looking back, how to deal with the past, to better approach the future. I will take into account questions of evidence available, reflect on the survivors, the affected communities, and their rights in international law in addressing past atrocities. Yesterday, it was a real pleasure to be part of a workshop with the Commission on the investigation and gathering of evidence, CJIL, that we had here in Erbil. And I can truly, and from the bottom of my heart, say I'm impressed with your work and with your continuous attitude towards your work, the resilience and persistence that you show. They have collected thousands of survivor statements that provide a rich source of documentation of the violations of survivors' most intimate human rights and their dignity. It is a critical mass of evidence that is available, especially here in this operating in a very unprecedented situation where it is currently not clear how all this evidence will be used in the long run. Yet, the difficult work continues, and I applaud this. CJIL does produce reports for third-party states, such as Germany, the Netherlands, France, and other countries, to provide information and prosecutions in those countries. But they can currently not facilitate actively prosecutions where it is most obvious, here in their home country. There is no law currently that would pave the way, that would open the doors to Kurdish courtrooms. The situation is currently one where evidence is scattered across jurisdictions. The evidence collected by UNITAD sits to a large extent in United Nations archives. CJIL has compiled a large repository of survivor testimony as well as physical evidence. Okay, domestic countries abroad have conducted their own investigations. Germany, for example, has conducted a couple of handful of successful ISIS prosecutions for genocide and is continuing to do so. And preceding, and this is, I guess, perhaps an important point to make is such a prosecution is what is called a so-called structural investigation, which first tries to aim to uncover the broader structure of a criminal, of a terrorist organization, to then be able to identify individual cases. Therefore, evidence and knowledge exists. NGOs as well, such as Yazda and others, just to name a few, have conducted investigations that contain valuable material. You all know this. And the relatively newly established National Center in Baghdad, CJO's counterpart, equally works on the prosecution of ISIS crimes and deals with evidence. Not to mention the evidence that would be available stemming from counterterrorism prosecutions. Already, just listing all this shows the fragmented nature of these different bodies of evidence that are there and that address the same thing. The current situation duplicates efforts, is unsustainable, and this is the most important point, the only entity benefiting from this situation is ISIS. This situation prevents effective forms of accountability, of holding responsible those who committed the crimes, of actually uncovering the full extent of their wrong. This needs to change. Actually, this week, exactly 80 years ago, the Nuremberg trials started, holding the Nazi leadership to account in a form of trial that was new to the entire world. 80 years on, we must not allow to go ISIS unpunished for genocide, crimes against humanity and war crimes, having brought death and destruction to your cities and communities, to the countryside, unspeakable suffering to a wide range of communities in this diverse society that you are, to the Yazidi people in Kurdistan and beyond. ISIS' unspeakable levels of violence and contempt for humanity cannot be met with impunity. However, what are the options? The International Criminal Court does not have jurisdiction unless Iraq was to join the Rome Statute. It would be a very good step, in my view, for Iraq to do so and send a strong signal of the active role that Iraq could play in the international community. But this seems far away and would not provide accountability at a large scale. The ICC would have limited capacities and usually always only addresses a small group of leadership people. Foreign prosecutions happen, yet they will only be a marginal response that does not address the vast majority of those who were mid-ranking ISIS leaders, their fighters, their supporters. This is one of the reasons why it is critical to implement international crimes into domestic law as a first step. Only then can you actually start to unlock the doors to Kurdish courtrooms. Courtrooms here to properly provide justice and accountability and uncover the full extent of the truth about what happened, and do so in a court of law. Well, the courts, and this is actually not just in Kurdistan or Iraq, this is all over the world the case. The courts are full. They're full of thieves and petty criminals. Those of you who work as judges know what your current workload exists of. I know this from my background as a practitioner in Germany, and very often I was asking myself, why? This is wrong. Yet, when you think of the gravity of crimes, very often the most grave crimes seem to continue to go unpunished, and on a day-to-day basis, we deal with so many relatively marginal things. To be clear, from an international law perspective, because this is one of the things that, of course, does come up as a big question, international law and international criminal law does not prohibit the retroactive application of the law in cases of international crimes. Since Nuremberg and since the inception of the Genocide Convention, it is clear around the world that genocide is prohibited. It has been outlawed. The prohibition of retroactivity serves to ensure that people can abide by the law and do not run the danger of being punished for something that was not a crime at the time, where there is no doubt that every ISIS perpetrator knew that crimes against humanity and that genocide and war crimes are punishable. There should be no obstacle to ensure that victims who have survived these atrocities deserve to see justice done. It is not simply a question of morale, but a question of law. These survivors have a right to justice, they have a right to have the truth uncovered, and communities all across Kurdistan have a right to truth. This right is important for the whole of society. It has a broad effect through education, learning from the past, and hopefully contributing to the prevention of atrocities in the future. A law implementing international crimes is a first step on closing the gap of impunity that exists to this day. Let me use the remaining brief time of my reflections to turn to the role of victims and the survivors of these crimes and what role they can play in criminal prosecutions. You all know about their roles as often central witnesses in trials, but it is also important to reflect how justice can properly be delivered for those for whom it matters most. In international law, new forms of victim participation in trials have emerged. In some domestic systems, victims have for a long time had the possibility to actively participate, which means to be represented by your own counsel, your own lawyer in court, to provide your views and opinions throughout a trial and on different matters that are discussed, to provide information on the impact that the crime has had. And last but not least, to even make submissions on questions of sentencing, on what the appropriate punishment from the survivor's view would be. The International Criminal Court allows victim participation in this way. Hybrid tribunals have victim participation. In the extraordinary chambers in the courts of Cambodia, for example, victims provided a very critical contribution in creating an understanding of what forced marriages did and do to people and how these constituted crimes. The Kosovo Specialist Chambers has it, the Colombian Special Jurisdiction for Peace as a relatively new jurisdiction does And domestically, just to name a few countries, the Netherlands have it, Germany does, Norway does, and many other countries do in various shapes and forms. They can provide most valuable input to ensure that justice is realized. I have not mentioned one country yet, France. France has very strong victim participation called partie civile in the French system. In a recent mass trial, now this is not an international criminal law trial, but nevertheless very informative. In a recent mass trial, Madame Gisèle Pellicot, a victim and a survivor of years of horrific abuse, who participated in the trial, opted to have this trial in public. Now, why is this relevant here? She was the only one who could have taken this decision as a victim actively participating. Normally, such cases would be behind closed doors, as is probably the case in Kurdistan as well. She said, and this is relevant, I want the shame to change sides. It is not me who survived these crimes who needs to feel shame. The accused who did this needs to be ashamed. This was not only brave as a woman to do, but what it did was in France and across Europe, it changed perceptions and it triggered debates and discussions all across society on questions of sexual and gender-based violence, really firmly bringing it into people's heads and minds. The shame needs to change sides. Now here, connecting back to questions in Kurdistan. Women who are mothers...
I'm sorry, one last minute
to
conclude. Thank you.
Women who are mothers to children from their time in captivity should not feel shame and be expelled from their communities and families. They need support. Women and men, everyone who suffered rape, who suffered sexual and gender-based violence, must not feel ashamed. The shame needs to change sides, opening courtrooms in Kurdistan for the prosecution of international crimes, and I'm really thinking into the future here, possibly allowing victims to play active roles in these processes, can be a big opportunity to address the past and work for the future. Thank you very much.